Welcome to HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. We hope you enjoy the show. Hello and welcome to the April 2015 episode of HR ListenIn. My name's Holmes, employment lawyer in Taylor Vinters' London office and presenter of HR ListenIn. Now last month you may recall that we did a 2-minute section on restrictive covenants. And for those of you who missed it, it's still available to download from our website. Restrictive covenants is a particular hot topic at the moment, so we thought it would be worthwhile looking at it in more detail. With this in mind, I'm joined by my colleague Anita, who is a partner in our employment team. Now, Anita, you and I both deal with restrictive covenants issues quite regularly, but this is certainly an area of particular expertise for you. So what are we going to be talking about today?
Thanks, Dom. Well, the law on restrictive covenants is constantly evolving. As we both know, there are a number of cases that come up through the courts where employers are battling to enforce their covenants. Today we're going to look at 2 cases that happened in the past year. I covered these in our recent employment conference, but there are some important lessons that are worth repeating.
Okay, so let's start with a quick recap of the basics, Anita.
Okay, Dom, so the basics are that basically there's got to be a legitimate business interest that the business is seeking to protect. Now, typically that would be your client base, the stability of your workforce, your suppliers, perhaps your confidential information. And the law says that the covenants must go no further than is reasonably necessary to protect those legitimate business interests. Now, historically, covenants were rarely upheld as they were deemed to be restraint of trade, which basically means that an individual wouldn't be able to earn a living once they left their employer. Nowadays, the trend has changed and the courts are more willing to uphold the covenants, which is great news for employers. The real key is to have a set of bespoke covenants that are as tightly drafted as possible for your key players. And those are the individuals that could cause most harm to the business were they to leave. So typically that would be your senior sales guys, perhaps your CEO or your CFO, certainly your business development manager or your marketing team, who would be very valuable to a competitor if they left because they have many of the client relationships and market intelligence. So the typical covenants that you find are a non-solicitation of customers covenant or a non-solicitation of staff covenant. Nowadays, you'll also see a non-deal of clients or non-deal of suppliers clause. Probably the most draconian covenant that we find is a non-compete covenant, which basically stops a departing employee from working with direct competitors for a period of time. Those covenants are notoriously difficult to enforce, and they really should be reserved for your real key players that you're really worried about.
Okay, and it's fair to say, I think, that when it comes to fighting it out in court, much depends on the particular facts.
Absolutely. I think it completely depends upon the facts. Really, the best advice we can give to employers is to have your covenants in the best shape possible so that when you genuinely need to have their protection, you've maximised the chances of achieving that.
Let's move on to our first case. Now, Profit and Hug It is one of my favourite cases from the last year, and it's all about making sure the covenants do exactly what you want them to do. What happened in this case, Anita?
So in this case, Mr. Huggett was a UK sales manager for Profit. He was responsible for 2 specific and unique products that only Profit made. He had a 12-month non-compete clause. However, when you literally read that covenant, it basically stopped him from working just on those 2 unique products were he to join a competitor.
So, if only Profit made those products and not their competitor, sounds like the covenant gave absolutely no protection at all to the employer. It was completely toothless.
That is exactly right, Dom. And the Court of Appeal basically said in their judgment that if there is an ambiguous contractual provision which could have 2 potential interpretations, one of which would lead to an apparent absurdity and the other which would be a commercially sensible solution, of course they're likely to favour the commercially sensible solution. However, in this particular case, there simply wasn't any ambiguity. The clause was very clear. And the Court of Appeal felt that Profit had, and I quote, made its clause 19 bed and must now lie upon it, close quotes.
So there's a clear lesson for lawyers there. But what about the terms of practical advice for employers?
So basically, employers need to make sure their covenants are really clearly drafted. They need to sense check them. They need to read them a few times. The reality is that lazy drafting is a recipe for disaster.
Our second case is all about what happens when an employer wants to introduce covenants or improve covenants for existing employees. It's well established that the enforceability of contractual restrictions is judged at the time they're entered into, rather than when the employer seeks to rely on them. In practice, this means that covenants often become outdated and are therefore ineffective as employees progress through the business and become more senior. Anita, tell us about the facts of this second case.
Thanks, Dom. So the second case is called Reuse Collections and Sendall. Mr. Sendall had worked for Reuse since 1980, and would you believe that for an entire 22 years, poor Mr. Sendall did not even have a contract of employment? Luckily, Reuse cottoned onto this in 2012 and presented him with a new contract. Of course, within that contract, there was a 6-month non-deal clause, a 6-month non-solicitation clause, and also a 12-month non-compete clause. Mr. Sendall trotted off and got some legal advice on those covenants, was happy to agree to them, and he signed them. Roughly a month before he signed up to those covenants, Reuse had given him a pay rise.
Okay, I can see where this is going. So he leaves, he joins a competitor, and Reuse tries to rely on the covenants, and he says he's not bound by them.
Exactly that. However, unlucky for Reuse, there was no consideration for him signing the covenants. As far as the court was concerned, the pay rise was not expressly linked to relate to the covenants, and therefore they could not rely on that as being consideration.
So a cautionary tale for employers, it seems to me.
Yes, I think the decision is quite harsh, but definitely the lesson to learn for employers is to have an express tangible financial benefit for the covenants, or alternatively have them set out in a deed.
We've looked at a couple of the key cases from the past year or so. Anita, are there any basic take-home points that you can offer to listeners who may be grappling with restrictive covenants issues?
Absolutely. I think the number one key take-home point is to always bespoke your covenants for your key staff. You should definitely check and recheck the drafting. If you are going to introduce new covenants or amend covenants at a later stage, ensure that you are expressly giving something in return for that, or alternatively have them set out in a deed. And definitely one of the real fall downs that we hear about a lot is to remember to update your covenants if employees are promoted.
I think often we're asked whether the courts are currently favouring employers or employees, and particularly the case in restrictive covenants areas. I think that's quite hard to discern at the moment as the courts are adopting an increasingly fact-specific approach. What do you think about that?
Yes, I agree. If you look at the two cases that we've discussed today, they both were against the employer, but we picked them because there were some important lessons for employers. But if you look perhaps at the last 6 most important decisions that occurred in the past year, 3 of them were in favour of the employer and 3 were in favour of the employee. So it is very difficult to see a trend either way.
That's about it for this month. Anita, many thanks for your company and wise words on this podcast. If listeners want to get in touch with you to discuss restrictive covenants, how can they do that?
Thanks for having me, Dom. They can find me either on the Taylor Vinters website, or if they did want to contact me directly, then my email address is anita.rai@taylorvinters.com. I'm also on LinkedIn, or my Twitter handle is @AnitaRaiTV.
Great. Now, our next podcast will be a post-election special in May. I'll be joined by my colleague Rachel Ashwood to discuss what employment law developments we are likely to see from the new government, whoever that may be. In the meantime, you can also access all previous editions of this podcast by clicking on the ListenIn icon on our homepage.